So Mr. Suman Batra
Hi.
is joining. Is he joining?
I don't think. Okay. So hi. Good afternoon, everybody. My name is Ashok Kumar from Black Oak in Singapore. It's for some reason we have lost our moderating our moderator for the panel, Dr. Suman Batra, and I think he will join as soon as he can. Apologies for the delay. He must be stuck somewhere. I'm going to try my best to just sort of moderate this with what little I know about Indian law on the issues that we're going to discuss today in Singapore law in the context of what's going on. Okay, what's going on here, and see how we could, open the floor for Q&A. I'm going to start first by just handing over to Dr. Mukulita, who is going to give us a 10-minute keynote speech. Doctor, over to you.
And I'm full-time member on the Insolvency Board of India. I think III with the Insolvency Board of India for this webinar on avoidance transactions. Good afternoon to all the learned panelists, professionals, and brothers and sisters who are virtually present. Good afternoon to especially Suman Batraji, Ashok Kumarji, Jyote ji, and other experts present in the webinar. Today's webinar is the third in series. So certainly the professionals who are attending, I think they have acquired enough, thought process, I think, in the past two webinars about the avoidance transactions. Now the word avoidance, it indicates something. It indicates that it indicates a normative behavior. Avoid certain kind of transactions. That means it is a kind of a mandate that don't enter into it, don't enter into such behavior, and which is not void. And in terms of contract, law of contract, is to be avoided. It's not an offense, fine. It may be an offense when we see the provisions of IBC under section 66 or other provisions in the provisions. But avoid, instead of declaring it as a void, just in a very polite, sophisticated way, in a soft manner, it has been prescribed under the IBC, under sections 43 to 51, about 4 categories of transactions: preferential, extortionate, undervalued, and fraudulent. So I think transactions or behavior of a corporate union which needs to be avoided, that has been categorized. There may be many more of such kind of transactions which they don't withstand the judicial scrutiny. They don't withstand the, I think, that in terms of values. I will tell about the values because avoidance transactions is something that I think its roots, or I think the basis which we can find in philosophy, we can find in terms of values also. But in 21st century, we are living in the age of corruption, greed, conflict of interest, violence, terrorism, and this coronavirus. And it has made our lives of human beings very troublesome, and that is certainly visible in the corporate unions also. We find that in the corporate unions also, the insolvency problem, such provisions were suspended. But whatever a human being does, that has a clear consequential reflection in the corporate universe. Because corporate entity is nothing, though it's a separate entity. But anyway, the people who are managing, monitoring the processes, involved in the business, certainly they are nobody but none else than the human beings. So naturally, this avoidance transaction, I think, the way we have for the individuals, certain good things, do's and don'ts. Similarly, for corporates also, we have do this thing, avoid this thing. And avoidance transaction falls, these transactions fall under this category of avoiding perfect transactions. preferential, extortionate, and fraudulent perfect transactions. So in this age, I think in this age of globalization, which has changed the concept of values as far as human beings are concerned, and certainly the values of corporates also. And avoidance transaction, I think it is the result and outcome of that only. Because of the globalization, any act may have positive or negative impact. Globalization certainly has positive negative impact. And in the age of globalization, we are living in an interconnected world, and certainly I think the ramifications of avoidance transactions may result in the cross-border insolvency also. And this is the act, I think, which is responsible to a large extent for the NPAs, for the insolvencies of corporates. And that is why I think during the conduct of the process, corporate insolvency resolution process, I think every resolution professional, I think in terms of jurisdiction of the Singapore, we call it as the judicial managers, every professional is required to examine and determine these transactions and file an applications. In India, more than 500 applications have been filed. And I think it involves our amount of around about 1.5 lakh crores. So it's not a small sum. It gives a message to the corporates in future. This avoidance transaction provision is not just to change the behavior or just to which helps in resolving the insolvency or getting exemption of the value of the assets. No, it's a message to all the corporates in future that if you do this way, such transaction will be examined by another third professional, which may put you in trouble, or because of that, the company may go into liquidation, the company may not be resolved. If the application is not disposed in time and you don't get back the recovery, under this code, I think, similar to this code, in 2018, Singapore has also enacted a very consolidated code for both the individuals and the company. And I think in this code, or in their code also, in their act also, which is in force from 30 July to 2020, they also, I think, mentioned about the wrongful trading. So all these transactions, they can fall under the, I should say, the wrongful trading as has been envisaged in the Singapore law. Now, how to prevent it? Whether these provisions have the effect of prevention in future of such transactions, because these transactions, there are two kinds of applications which are filed under the Insolvency Bankruptcy Code. One is for the purpose of insolvency resolution. The other is if you find during the course of conduct of the process, you find such transactions, and certainly you have to file an application. It's your duty to file an application. Maybe you are a resolution professional, or maybe you are a liquidator. In both these processes, if you come across such a transaction, naturally you need to file. Now, this is a kind of a corporate social responsibility, I should say, of a professional, or I should say professional responsibility, that he has to see all that, but that has been formally articulated and envisaged in the code itself. It's a kind of, whenever we investigate, we see something and we find that it's going wrong, it's not proper, or I think this cause is responsible for the NPA, this cause is responsible for the insolvency. Certainly, it is important also. It may not be important, that too, but it may be important, because if the recovery is, I think, crores, or the volume of recovery is huge, certainly it may have a good impact on the recovery, or the resolution applicant. Good resolution applicants may find that, yes, I will get this money back, and certainly I will be able to run the company. So avoidance transaction is I think it's a kind of a setting the values in the corporate universe. Importance of values in the business ethics, I think, shows that how important is the values in the business ethics, and how important is the social responsibility and sustainability of any business. And I think this avoidance transaction, which is categorized under 4 acts and in this code, certainly I think now we have seen that these applications nobody, I mean, I should not comment on the judiciary because the infrastructure is not that adequate at present, keeping with the number of applications. But certainly, I think admission CRP applications are important, but these applications they are filed, but their disposal, no time limit has been set in the court about the disposal of the applications. That is why I think the result or the fruits of these applications or disposal of the impact that disposal applications can have, I think, which we are not able to have visible impact of these applications because there are many applications are filed but not disposed of because we have provision that irrespective of disposal, CIP process can be concluded. And I think that gives a message that those applications may be in the nature of recovery, may not help in resolution. They may have a far-reaching impact, maybe like that. But I think it is wrong on the part of business entities to, to interpret that those applications are not very important. I think avoidance transactions, they set the values and there is a great impact of these applications on the society, on the business. And I think in the globalization, there is a process of international integration. And I think avoidance applications may have an impact of setting values in the corporate world. And on this occasion, I think I referred to the teachings of Buddha, and there are certain principles which Buddha has given for business ethics. And I think he has given eightfold, I think, for business ethics. I think he has given certain teachings, and those are eightfold: right knowledge, right resolve, right speech, right conduct, right livelihood, right effort, right mindfulness, and right meditation. I think all these three, I think these are teachings of Lord Buddha, and which may help the businessman in evolving values, doing the business in a right way so that we can have a ease of doing business and ultimately to have ease of living. Any law, any act, any activity of any individual or the corporate, they affect the ease of living of other person. So certainly the corporate universe, if they also adopt the values in their transactions, I hope that the process of justice, especially in the sector of the commercial disputes, may be fast because we have to wait, or who will follow up the evidence applications. So speed of justice, sustainability of the businesses, trust of the stakeholders, customers, I think we may generate, business entities may generate trust in their customers or the employees or the claimants if they follow values in their transactions. And that is why we call these transactions avoidance transactions. They are not offenses, but these should be avoided. And for avoidance, to bring back, I think there is a direction under the code in these sections 40 to 51 to revert back the situation. That it is a kind of civil wrong. It's a kind of civil wrong to revert back the situation and bring back the CD. But question here lies, if there is a resolution completed or concluded, then bringing back those values, then who will be the beneficiary, resolution applicant or the creditors? I think is still certain, points are there which are debatable, which I think panelists will discuss about it, and how the things can be, how this process, CIP process, can be strengthened through these applications, through the disposal of these applications. With these words, I conclude, and I expect that the panelists of this webinar, they will discuss the fine niceties of the process of this process of evidence transactions and how these should be disposed of, because the human, nature of human is alike. Because of geographical, differences, maybe, I think all laws, I think processes may be a little bit different, but behavior is same. Value should be same. Of a particular century, value should be same. And I think we are living in a changed environment where the values have been declined. So let us improve the value system, both of individuals and the corporates. With these words, I conclude, and I wish the panelists to discuss issues arising out of this avoidance transactions. Thank you. Thank you very much.
Thank you. Thank you very much, Doctor. Okay, so first and foremost, I've got a message from Sumant, who sends his sincere apologies. He is stuck in a Supreme Court hearing. So it falls on me to try and give some shape to this session. Okay, let me start first by just sort of marking out a few things. First, let me introduce my fellow panel member, Jo Tay, from Allen and Gladhill in Singapore. Now, some observations. Doctor has said, look, corporate governance, accountability seems to be one of your key drivers, okay? I'll just sort of share with you what are the sort of drivers that sort of affect how we see this sort of legislation, the insolvency legislation in Singapore. First, there is the corporate governance element, right? I accept that, okay? It is about a stick approach that's there. If you do something wrong, okay, it could also be a breach of duty for you to have allowed those avoidance transactions to have gone through. Secondly, it is a tool for value extraction to sort of help impregnate the assets to give more, recover more, and give more back to the creditors. So there's these two drivers, okay. And at the heart of that is the pari passu rule, that when the company really is in a situation where it's insolvent or becomes insolvent as a result of the actions that have been taken by the directors of the company, okay, that you must try and the pari passu rule sort of creeps into the whole concept and the thinking behind the legislation. So these are the key drivers, policy drivers here. Now, the other thing that is this, and Joe will get into the meat of what we have in the law here, okay? Unlike in India, which is what I'm hearing your new legislation is, and you know, I hope I got it right, but I understand how it works in India now, is that there's a mandatory obligation for the RP to actually do this, okay? Actions. And then there are saving provisions and provisions that are allowed if the applications don't end by the time the resolution is meant to have been done in the 270 or whatever number of days you're supposed to do this under the IBC. And then it continues into formal insolvency if the company slips into liquidation or whatever, or it gets built somehow into the resolution plan if it's a restructuring, okay? This we don't have, okay? So the mindset here is that, first of all, in restructuring, there's no real application of the avoidance provisions. If you want to bring some value back, you'll have to find a way to do that within the confines of the restructuring plan, in our case, the scheme of arrangement, okay? They exist in judicial management and liquidation, and Joe will get into the meat of that. The other thing is that it is not mandatory. It's not mandatory simply because we have this rule called the estate cost rule, that if a liquidator or a JM starts, and a liquidator for sure and JM probably, that if you start an action and in the name of the company, even if it's in the name of the company or yourself, and you don't have enough money to from the bankruptcy estate to pay counterparty costs, if you lose, the IP is personally responsible for the cost. So it's very risky, and there's a rule. Okay. It's very key that IPs start the actions without that risk, or managing that risk. That has led to law reform for the raising of litigation finance to pursue these sort of actions, okay? So with that, I'm going to hand over to Joe. Please, if you have any questions, please put them through, or what we could do is perhaps take those questions at the end of the session. Whatever it is, we'll try and weave in one way or the other your questions and answer them. Okay, Joe?
Thank you, Ashok. So as Ashok said, maybe I'll just give a very brief introduction to the kind of avoidance actions that we have under Singapore law. And I'm just going to echo his invitation. Okay, if you have any questions, please feel free to just type them into the Q&A window. Okay, and then we can take them one by one. I think we have enough time left after this to cover some of the Q&As that will come in. But maybe just and I do propose that this conversation be more fluid and free flow, because well, Ashok and I are here in Singapore where it's almost Friday evening. We're relaxed and more than happy to just speak casually about this topic. Okay. So let me just go into what we have in Singapore, just by way of background. Okay, we have two restructuring processes. One called the scheme of arrangement, where you have the management stay in place. So that's a debtor in possession procedure. And then you have this thing called judicial management, which is basically, if anyone is more familiar with the administration process in the UK, we took that many, many years ago, brought it over in the 80s and gave it a different name called judicial management. Okay, and that involves having a third party come into the company to try and restructure. So normally that happens when perhaps the creditors lose faith in the management of the company and they say, well, I think you should get out. I think we want an independent insolvency officer to come in and restructure the company. And then at the end of it, at the end of the company's life, you have liquidation. Okay. So I think what we're going to talk about here is set in the context of judicial management and liquidation, which are the two processes in which you have a separate third party come in, right? And say, hey, what happened here? And I want to see what the management did before that. So that's the focus of our, I suppose, the analysis and where the clawback actions happen. Okay, so in Singapore, the judicial manager and the liquidator each have the right to bring clawback actions, i.e. to look back at the transactions that took place before the company entered into judicial management or liquidation, and question them and say, hey, should these transactions have been entered into or not? Okay, and we'll go through the grounds on which these transactions can be questioned. This is actually a fairly significant work stream of the judicial manager or the liquidator once they take office. Because when they go in, they have a whole bunch of things to do, like get up on, actually, what was this company's business? Are there any receivables we can realize? And then they also say, well, let's also look back at the transactions for the past number of years and see if, well, there were actually any monies that flowed out that shouldn't have, any assets that were distributed that shouldn't have been, right? And then we commence actions to claw these back so as to swell or increase the assets available for distribution to the creditors of the company. So that's kind of like the thinking around, thinking by the judicial manager or liquidator in entering into this, taking up this work stream. Okay. So, I mean, I'm aware that some of our attendees would probably also have attended the previous talks in relation to the UK and the US clawback procedures. The ones that we have here are very similar to the UK one, so I probably won't spend too much time on it. I'm fairly certain you'll start to recognize them once I go through these broad categories or broad grounds, okay? So the first one, the main one is the transaction at an undervalue as well as unfair preference. For transaction at undervalue, the judicial manager or the liquidator, i.e. the insolvency practitioner, goes in, looks back 3 years into what happened with the company and says, well, was there something that the company gave away as a gift or traded or passed an asset to someone else for much lower value when the company was actually insolvent, right? And that becomes a potential area for clawback. The second one is an unfair preference. So that's when the directors of the company perhaps did something to put the counterparty or one of the creditors in a better position than they would have been in the company's liquidation. So for example, in many of these family-run companies, where there are also debts that are owed to family members or relatives, sometimes the directors, in understanding that the company is running close to insolvency or is facing claims, may say, well, let's just pay off this auntie or what is uncle who lent us money first, right? Whereas if the company had gone into liquidation, that auntie or uncle would actually just have received a pari passu distribution. And therefore, there would have been an unfair preference in favor of that specific creditor that should be clawed back. And this one, normally, they would look back 1 year if the person was not connected, look back 2 years if the person was connected. The other, well, I suppose less common ones, but are also still available are, for example, extortionate credit transactions. If the company entered into some sort of credit arrangement for super high interest rate prior to the insolvency of the company, that's something that the insolvency practitioner may look at. Or, for example, if the company gave a fresh floating charge for no new value 1 year prior to the entry into judicial management or liquidation. Now, this one, and we can talk more about it later, might be something to be careful about, especially in helping to restructure a company informally, because very often when we go into informal restructuring, right, the creditors are aware that the company is having financial problems, but they say, well, we won't put you in winding up if you give me a floating charge or some sort of security over your assets. At that point, I think we do have to think ahead and see if that might potentially be challenged later, you know, notwithstanding that we did all these to help the company, it goes into judicial management or liquidation. Of course, there are defenses in each case. So for example, for transaction at an undervalue, it's a defense if the company can, if the parties can show that actually when the company entered into this transaction, it was in good faith and there were reasonable grounds for believing that it would help the company, right? Or for unfair preference, actually there was commercial pressure, there was actually no intention or desire to prefer that specific creditor. Okay, so there are all these defenses that come into play if a claim is brought. So those are the kind of examples of avoidance actions that an insolvency practitioner would usually look at, together with the assistance of their legal counsel or their lawyers at that time, right? And then they decide that they want to commence proceedings to claw back those assets. Now, I think I'll also add that in recent times, the Singapore courts have been very, very clear that there is also personal liability for directors that are involved in these transactions. So how does that work, right? And I imagine that this would probably be the same in India, that the directors have a general duty to act in the best interests of the company. And when the company is insolvent or in the shadow of insolvency, they have to consider creditors' interest in deciding, you know, actually what is in the best interest of the company. But by causing the company to enter into these vulnerable transactions, transaction at undervalue or unfair preference, well, clearly they don't seem to be acting in the best interest of the company by reference to the interest of the creditors, right? So there's often a parallel claim that can be established against the director for personal liability if you manage to also establish. Finally, there's also this issue of wrongful trading. Directors can be personally liable for causing the company to take on debt at a time where actually the company is not capable of paying back this debt, and therefore it's wrongfully trading, right? There's personal liability for the directors in this case. So I mean, generally there are all these different avenues under Singapore law that the insolvency practitioner can look at as one method of saying, well, how else can I take back assets into the company so that we can have a better recovery and better distribution to the creditors of this company who are actually looking to me, right, to do the work and give them a better recovery in this case. Maybe I'll just pause here. Yeah, I think I'll just hand over to Ashok for a couple more comments in this respect.
Yeah, thanks a lot, Joe. So, look, having heard Doctor, I think the clawbacks that we have here seem to be similar to what you have there. I mean, the elements may be slightly different here or there, but I think broadly speaking, it's there. But it seems to me the policy drivers are a little bit more weighted at corporate governance than they are on the recovery side, because the way we see it, the way I see it at least, I don't know whether Joe agrees, but the way I see it, the fact that it's a hard requirement to actually commence the action, to me, is more like a hammer rather than a stick, rather than a tool to actually, because I think it's quite an ask from outside looking in. It's quite an ask to impose such a hard obligation on the RP. Investigate, conceptualize, find the money, sue, and try to finish as quickly as possible. It's quite an ask, okay? Which is why in Singapore, it is not an obligation, okay? It is not an obligation to pursue those actions. And essentially, like Joe says, the liquidators or the JM's job, right? In JM, it's actually a restructuring regime, okay? The primary obligation is rehabilitation. The primary focus is rehabilitation. Litigation can be a sidetrack, okay? And can derail the restructuring. People get stuck into it. Sometimes, you know, the shareholder is part of the solution, and in the end, it's about what value you can extract best in the total scheme of things. Okay, liquidation is of course a different point. In liquidation, it's pure recovery. Okay, the willingness, first of all, the time pressure to actually commence those actions are not there, right? Because the clawback periods are locked in at the time when the application for liquidation is filed, right? And there is scope and sufficient time for the liquidator to look at it and then consider whether this is really beneficial for the purposes of the winding up or not. Because the primary driver here is, can I get anything out of this for the creditors? It's well and good for me to start left, right, and center and sue everyone, okay? Cost money, can I get a recovery? Because that should be my objective, okay? That's our mindset here, okay? Right or wrong, I don't know, but that's the way it really works here, okay? Now, to fund those actions, okay, that's a really big problem, right? Most of these companies have no money, okay? So avoidance actions, already before our new legislation came in, litigation finance for liquidators and IPs was already allowed by common law, right? In the court accepted that you could first of all, you have a right to sell assets, you have a right to assign proceeds of the litigation. All this you have statutory rights to do. Okay, there were other reasons why the court also felt that you could actually enter into a financing arrangement and get it approved by court. So I did the first of those cases in Singapore, a case called Vanguard Energy. But that wasn't enough for avoidance actions, because avoidance actions, in some cases, the right to sue is actually in the hands of the liquidator, the individual, not in the name of the company. Okay. So there's a big question whether you have a statutory right to assign something that actually is not really the company's, but yours. So, but the new law has come in to actually fix that. So now you can do all of it. Okay. The IP can go out there and raise finance to pursue these actions. Okay. Which deals with the estate cost problems, which I highlighted earlier. Okay. You just have to meet certain obligations. We don't allow contingency fee arrangements for lawyers to act for these people. All right. So we have our own guidelines, which are to make sure that we also don't, when we engage in this sort of activity, we follow a certain set of principles that don't compromise our integrity as lawyers. Okay. So the whole thing works together in one piece of legislation to pursue these actions. But we don't have an obligation, a hard obligation like you do, to pursue those actions. So I would like to know, and let's get into a discussion on this, on whether it is really a driver. What is really the driver in India? Okay. And maybe Doctor, you can step in here. Is the driver primarily corporate governance to instill discipline, because they know that this is a real problem that can happen? Or is it a recovery tool? That is a question really I was going to ask Sumat, but he's not here to answer my question. So, I'll be interested to know that. But it's not the way we do things here. For us, it's fundamentally a recovery tool. Okay. Corporate governance is dealt with in a whole host of other ways. Okay. And generally, promoters here are held accountable. Okay, if they've done something wrong. Okay. So we don't, the focus is fundamentally on recovery. We have a question here. Whether hiving off an unprofitable unit area of operation prior to CIRM within the stipulated time period will be termed. Okay, so this is a direct question on Indian law, which I unfortunately am completely incompetent to answer. So are you able to help with the answer to this? Something more for you're on mute, doctor. You're on mute. You're on mute.
Yeah, I think you are audible now. Am I audible now?
Yeah, we can hear you, doctor.
Yeah.
I think hiving off an unprofitable unit prior to CRP can be termed as an unavoidable transaction. I think it all depends on the circumstances and the situation and the context, and how it has had the impact on the finances of the company. And just let me tell you, along with this question, that we have preferential, we can judge it's a preferential transaction. But as far as the undervalued and extension is concerned, I think extension also an undervalued. I think pertains to the relative value in the market, whether it is undervalued or it is extortionate. I think what is the limit, how has to be determined, what is the process that we have accounting standards. Do we have that kind of thing for determination by the resolution professional that you will term it as a undervalued or you will term it as extortionate? And in this world, I think when we have different circulars in the market for the registration of the immovable property, and the payments made is different, everybody knows all that. So in those cases, how to determine undervalued and extortion transaction, it's a big question, and I think it requires an in-depth study and outlining those parameters where or the criteria which will facilitate RP to determine undervalued or extortionate, and to what extent whether these transactions were responsible for the insolvency or not. If really they were the causes of insolvency, certainly I think their disposal should be within the time limit of the CRP also. If not, certainly it is a recovery process and it can be recovered later on. But if it is the cause of insolvency, the best way is that those should be disposed of. But all depends upon the circumstances and the context, situations.
Okay. Thank you, Doctor. Maybe Joe, you wanted to answer that question in the context of Singapore law. You want to? I saw something here.
Maybe I could just add. I was saying that this question would be answered live by Doctor, but I was thinking of adding perhaps how we might approach it from a Singapore lawyer's perspective, right? If we were in the mode of an insolvency practitioner looking back at the transaction, I think I agree with the approach that Doctor suggested. You would have to really consider all of the circumstances, right? Including actually why was this disposal done? And of course we can say one of the reasons was it was an unprofitable unit. Okay, and maybe we were trying to restructure the company. Okay, sounds okay. What was the value of that unit when it was disposed, and what was the value received for that unit, right? So for example, if it was unprofitable, but it was actually worth like $30 million US, but all that was received was $15 million US, then we would question, oh, well, even though it was unprofitable, maybe there was some valuation that proves otherwise. You should have received at least a little bit more for that. Then maybe it would be still a transaction at an undervalue. So I would say actually there are a lot of questions that we would have to ask around that transaction before we turn around and say, well, we are so sure that this transaction is vulnerable. It should be questioned and it should be clawed back. Taking from a different perspective, if we were advising a company in distress, but before it enters into some sort of a formal proceeding, right? And there's always a shadowy period when the company is like, oh, I'm in trouble. Can I do this? Can I do that? I think we would advise, our advice would be, look, if you need to hive it off, but you have to be very sure that, one, you can prove that this is in the best interest of your creditors. So maybe you need to back it with some sort of professional report, which says that if we keep holding on to this, we cannot meet the costs, we can't keep up with the costs, the money is not coming in, and there's somebody who is willing to take it for this amount, we think it's fine, it's better for the creditors this way, right? And you have that backed up with directors' resolutions as well as your professional report. And I think in that way, projecting forward, if the company gets into trouble, the directors at least have something to protect them and something to look back on and say, oh, well, actually, this is exactly why the transaction was entered into, and we have a defense to a potential clawback transaction. So that's what I had to share from a Singapore perspective, right, Ashok? Maybe we can go on to the other Q&As. Oh, Ashok, please go on.
Yeah. So just to add on to that, no, this twilight zone before you get into formal insolvency and you're facing all these problems and having to make tough decisions on the business. Okay. And that's really where one has to balance a tension between holding the directors accountable and putting them on the hook, okay, and encouraging some level of a rescue mentality to try and do things, okay, to save the company and entrepreneurship. If one goes too hard, then entrepreneurship also suffers. So this is the competing policy and tension, okay, which you guys really need to think about, because to me, I think that, and particularly so, and I'm looking now at what someone has put on the chat, Mr. Mehra has said. I mean, it's really, I understood that you could actually continue the action if the company slips into liquidation or roll it up into the resolution plan in the restructuring. But it appears that this Venus case says no, right? Of course, I'm not in a position to doubt that. But that makes it very difficult, okay, for the IP to really, in a very short space of time, think about rescuing the company, come up with a resolution plan, investigate the transactions, find the evidence, find the money, and finish it all in a short space of time. A lot of components there. I can see a lot of trepidation of RPs wanting to do that. Okay, it's hard, right? So I sympathize with all your RPs out there. I don't know who's an RP and who's not. Now, there's another thing here from Mr. Mehra again, okay? He says, possibly we could think of third-party funding, just like arbitrations worldwide, contingent success fee funding. Okay, so that's policy, really. I mean, is your profession ready for contingency? We are not. Okay, I think when it comes to contingency fee arrangements, somehow or other, Joe would agree with me. And unfortunately, our policymakers are not going down that path. But they are certainly looking and allowing litigation finance. It's opening up. There are a lot of players who come to Singapore. They're set up like investment funds. Okay, so it's an investment grade asset. They have their own LPs investing into these funds, investing into litigation finance, run by very, very professional people. Of course, you have those who are not really as professional. Then you just weed out the bad ones from the good. Okay, and you need to go back to court for approval anyway. Joe, you want to add to that?
Yeah, I mean, just in terms of the Singapore experience on litigation funding, so let's put aside like contingency and success fee, which is also, well, it simply is not happening in Singapore, right? But I do recall, you know, just a number of years ago, before like Ashok's case on Ray Vanguard came out in relation to litigation funding for insolvency claims, right? There was so much reluctance on the part of creditors or even the insolvency practitioner to maybe commence clawback claims. And as Ashok said, and we can understand it's by reason of funding. So for example, you have the judicial manager or the liquidator at the time going around to all creditors saying, hey, there's a potential clawback claim. We may or may not succeed, but would you like to put in more funds for me to try getting back the money, right? And if you have a bunch of traditional bank lenders who are already out by few millions of Singapore dollars, all the banks would say, how do you expect me to get clearance to give you even more money for you to try and get more money back from me, right? And trial might take place maybe 2-3 years down the road. So how am I as a bank officer going to explain that to my bosses even? So there was a lot of maybe just lethargy, inertia around it, which is why I think that when it became very clear that you could fund insolvency claims, and the third-party funders just came onto our shores very, very quickly, and I think it's just such a good avenue to get these claims started. Because even if the traditional lenders or the existing creditors don't want to, or they can't get clearance, right, to come up with more money, so you have these guys coming in saying, well, we are willing to take a bit of risk, we'll get something back for it, but ultimately, well, you as creditors stand to gain something from it as well. And I do see that, I mean, this is anecdotal, but ultimately, I think there is more interest in commencing and more willingness to commence the clawback claims or the avoidance claims after we made it very clear that litigation funding was allowed for this kind of claims.
Yeah, and look, it's just to give you a sense of pricing for that. It's not uncommon for the funder to take as much as 50% of the proceeds. Not uncommon. Don't forget, the funder bears all the risk. So, look, I mean, just to answer Mr. Mera's question, okay, it would be good, all right, for any jurisdiction to consider opening up in a measured way, third-party funding, okay? It does, like Joe says, first of all, it's from an economy point of view, it's new money coming into the system, okay? Secondly, it just gives creditors an opportunity to get something instead of nothing, okay, out of these claims. Some of these directors actually just sit there knowing that there's no money to pursue these claims, and now that mentality is no longer there because they know third-party funding is available, and third-party funders, third-party financiers are hunting for these kind of cases all the time. Contingency fees, I don't know. I just hope it doesn't hit our shores. Okay, so with that, I'm going to cover a few topics that Suman was going to sort of lead into. Mediation was one of them, all right? Is mediation something that is open for these sort of avoidance? Of course, mediation is open for any litigation, right? Okay. But to get people into mediation, people got to voluntarily submit, okay? Because it's a voluntary process into mediation and a voluntary process to conclude a mediation, okay? So the question is whether you guys, Singapore has decided not to do that. I tested this and failed, okay, to try to get the court to order parties to go for mediation, okay? So involuntary into mediation, but voluntary in mediation. In other words, you're forced to go into mediation, but you're not forced to settle, okay? But the court was uncomfortable with that, okay? But I personally believe, okay, that it's a good thing. It happens in the US courts quite regularly. In fact, mediation is used in the US to clear even commercial roadblocks in the restructuring. The court orders the parties to go for mediation, and sometimes even goes to a brother or sister judge a few doors away to say, you sit as the mediator and try and resolve this for us. So mediation is an underutilized tool. The problem is you've got to find a way to get people into the room. That's the challenge. Joe, you want to add anything to that?
Yeah, I mean, I do recall a couple of years ago, we had, I think, these US judges come into Singapore and also try to encourage everyone to mediate insolvency claims. I don't actually know whether there was an uptick after that, because, you know, if you have an insolvency proceedings and they somehow enter into mediation, sometimes it's just a settlement that's confidential, right? So we don't really have maybe numbers or more information about it. But I do agree that it's actually very helpful, and sometimes I think it's probably a more cost-efficient manner of a cost-efficient way of resolving some of the issues, especially when you're dealing with an insolvent company already in the first place, right? I think I have an example. I came across one situation where I felt the court simply did not want to hear the issue before it and push parties to come to a consensual solution. Okay, that's also in the insolvency context, not in the context of a clawback claim, but in relation to certain moratoriums that were in place. And the financier who had financed, for example, 25 construction machines, said, I want leave to enforce. I want to be able to take back my machines, notwithstanding this moratorium. And if this matter actually went to court and parties insisted on litigating it, the judge would have had to sit there listening to parties discuss each machine one by one and say, well, I need this machine because I have this project, etc., etc. And judge clearly did not want to hear that. So he was very clear in that situation that this is not a matter that you should be fighting over. Go away and find a solution to this, and then come back and ask for a consent order. So you have a binding court order, but it's with a solution that the parties had reached by negotiation outside of court. Okay, and I do think that that was one of the examples of a good use of outside court time to reach a consensual solution that still had the backing of the court, and we managed to avoid litigation in that sense. And I would encourage, if it's possible within the Indian framework, for perhaps practitioners to consider whether there are other ways of reaching a consensual solution so as to avoid the litigation time costs, if actually there is a better way of doing it. Right.
Doctor, what do you think, Doctor? Do you think that in India there will be appetite to appetite? Sorry, you have to leave?
No.
No.
I was
Do you?
thinking, yes, in
Sorry.
this context, the issue raised by you, I think we have clear provisions under our code. If a RP makes an application before the adjudicating authority, then what adjudicator has to do it? What kind of order the authority needs to pass? I think that is very clear. For example, in case of preferential transaction, the order may be passed to require any property to be vested back in the corporate debtor. So here I think I can't find any solution regarding mediation, because if the property is in the custody of another person, which has been I think passed on because of preferential transaction, undervalued. So if he has that possession, okay, fine, but he is sold off and he got some benefit out of it, then there we can have mediation.
That's true.
But then we can have mediation. But sections 44 or 47, I think they give directions to the authority what kind of orders will pass to vest the property. Usually in all the kinds of, I think, all the categories of evidence, there is I think first and foremost is there that the requiring that property to be transferred back to the corporate debtor. Secondly, if we require any property to be vested, if it represents the application for proceeds of sale of property, or any interest in that property or benefit arising the property. I think there are many kinds of orders which the authority can pass. So mediation will apply to which part of that order. I think
Okay.
that
So you see, you raised
may not be possible.
You raised a very, very important point. I mean, clearly, Joe and I have been talking about court order mediation, but that only works if parties are before the court. Okay, and that's your point, right? So really, maybe what you want to what can possibly be considered. I mean, of course, I don't know whether it will work, and really, you are in the best place to see whether it will work. But one way is that when the mandatory application is filed, okay, the parties are before the court, including the third parties who receive the benefits of the transaction, right? Okay. At that point, is there another fast-track dispute resolution mechanism that the court can order them to take, whether it's court-ordered mediation, expert adjudication, or some sort of truncated dispute resolution process, so that it fits within the confines of the 270 days that you have to finish the plan by? That way, it's the best of both worlds, but it's theoretical. I don't know whether it'll work.
I think here we don't have a provision like that. The authority may pass order as it deems fit, or as it considers fit. Then certainly these possibilities are possible. These things are possible. But when we have clear mandate, I think the court gives clear mandate or clear instructions dictate to the judiciary, I think authority, what it has to do. Then in that case, I think the discretion has been curtailed. And if we expect that even if the authority is willing or the parties are willing, but then we need to amend the law. Otherwise,
the law needs to change. Only the law can fix that. So that's an interesting point. Now, there was another thing that Suman was going to post to both Joe and I on this chat. I think we'll end off with that one, which is, how is avoidance perceived in group insolvency? So I'm going to pass this off to Joe, but I'll just sort of set some understanding. Group insolvency is a big thing now in India. Okay, everyone's looking at it. The law reform is not really there. There is an arbitral model law of group insolvency that nobody has accepted and adopted into their law. Okay, so group insolvency can be domestic, can be cross-border. Okay. So if it's cross-border group insolvency, I think that one's a complete minefield. We can finish one whole hour just talking about that. But let's just share with you how it works. Perhaps these provisions work in a group situation, okay? And then leave the cross-border issues out for Suman to turn up and ask us that question next time round. Joe?
Okay, well, I mean, assuming, let's just confine the issue to, well, you have a group insolvency in the same jurisdiction. So for example, in Singapore, right, there have been a number of such cases in Singapore recently, especially in the, like trade finance and shipping kind of situation, right? I think and I don't agree with this way of thinking. A lot of people think that you go into insolvency as a group, and then you think about clawback actions against third parties outside of the group. I don't think that is sufficiently nuanced. In fact, I think the starting point is that every company in the group goes into insolvency as a separate legal entity, right? And each of these companies have their own set of creditors. So the liquidator or the judicial manager has to look after the interest of that set of creditors of the company. And which means that they also have to scrutinize intercompany gains or intercompany transactions that went on. So for example, you might have a situation where you have company A, company B, company C, all part of the same group. Company A actually entered into a transaction with company B 1 year before. Both of them went into insolvency, right? Or maybe company A went into insolvency first. But different entities already, because the liquidator or the beneficial manager of company A has to turn around and has to look at that transaction with company B and say, actually, what was that? What was that? We need to question that, right? Which also means, I think in practical terms, when you have an insolvency practitioner appointed to one company in a group setting, it may not necessarily be the best for that same insolvency practitioner to be appointed to another company in the group, right? For example, if the same person is appointed to company A and company B, he gets into trouble because he might have a conflict of interest, right? He might have certain information in relation to company B that he might actually want to use in his role as insolvency practitioner of company A. And so I think at least my suggestion would be to be pretty careful when taking on a role in the context of a group insolvency, in case the practitioner himself finds himself or herself in a difficult conflict position. That's one. And then I guess the second takeaway from that is that when you have a group, ultimately in an insolvency, you have to split them up and think about them on an entity basis, okay? When we get into questioning issues of clawback, because you actually have to go and look at intercompany arrangements as well.
Thank you, Joe. That was a good explanation of how it works here. So with that, I think we have run out of time, really. We were expecting a lot more questions, but there were some very good questions there, and I hope you found this whole session helpful and useful. Every time I speak before an audience in India, I keep saying this, and I say this again. We are a tiny dot in Southeast Asia, tiny, small little guy, okay? Very easy to manage. Our policies, our considerations, our society, everything is simpler, okay? India is a bigger country. What works for Singapore doesn't necessarily work for you, okay? In the end, even in Singapore, when we decided to take and learn from other jurisdictions, we always fitted it into what is relevant to our own jurisdiction. So with that, thank you everyone for bearing with us. And again, I apologize for Sumat, who sent me another message to say, please apologize to everybody. He really got stuck in that Supreme Court hearing. And thank you, everyone.
Thank you.
Thank you. Have a good weekend.